but we have the State Secretary from the Ministry of Justice of Sweden, who of course hold the EU rotating presidency at the moment. So please, a warm welcome for Mikael Kullberg. Thank you very much, sir, and the floor is yours.
Thank you. Dear colleagues and friends, first, let me say thank you for inviting me to be a part of this year's International IP Enforcement Summit. It is a great honor for me as a State Secretary to the Ministry of the Swedish Justice and as a representative of the Swedish Presidency of the Council of the European Union to be given this opportunity to share some of our views on the importance of a strong framework for intellectual property rights. As this summit draws to an end, so does the Swedish presidency. I would therefore like to take this opportunity to give you an overview of our priorities and what we have achieved during our 6 months. First of all, it's important to remember that Europe is a major player when it comes to innovation and production of cultural content. Our continent is the birthplace of many successful and global companies. European nations are prominent in global innovation indexes, and we possess a strong and forward-looking industrial base. IPR-intensive industries generate millions of jobs in the EU and close to half of the total economic activity in the Union. They are also extremely important for the EU's trade with the rest of the world, as well as the EU's internal market. It should therefore come as no surprise that an overall priority for our presidency has been the strengthening of European competitiveness. It is only through competitive and innovative businesses that we can create sustainable growth, accelerate the green and digital transition, increase economic resilience, and strengthen the EU's geopolitical importance. And of course, one cornerstone in achieving this is a strong intellectual property rights framework. Not only do IPR-intensive businesses stimulate economic growth, but they're also key to meeting societal challenges in a rapidly evolving world. Intellectual property and assets serves as the bedrock upon which innovation thrives, providing necessary incentive for protection of creators, inventors, and entrepreneurs. For us, active engagement in IPR policy and in an efficient, business-friendly regulatory environment is therefore of vital importance. As you're all very well aware of, there's a lot happening in this area, and the last 6 months has been no exception. During the Swedish presidency, we have continued to build on the European Commission's IP Action Plan and advanced several of the legislative files in the IP domain. In May, we managed to conclude the trilogues and reach an agreement on the regulation on geographical indication protection for craft and industrial products. Once formally adopted by the Council and the Parliament, the new rules will extend existing protection of agricultural products such as champagne and prosciutto di Parma to also cover products such as Murano glass, Solingen and cutlery, and Carrara marble. The aim, of course, is to promote and protect cultural heritage and traditional know-how in Europe. We have also made substantial progress when it comes to the review of the EU design legislation, where a state of play was presented to the Competitiveness Council in late May. It is our firm belief that the stage is now set for a general approach to be adopted within short and during the incoming Spanish presidency. When it comes to copyright, we have focused on the Commission's follow-up on the ECJ's judgment in the RAAP case, which calls for action at EU level regarding remuneration to music performers and record producer from third countries for music played in the EU. Also in this area, progress has been made, and we are confident that the work now being done by the Commission to find a balanced solution to the benefit of all member states will bear fruit. During our presidency, the Commission has also presented several new legislative initiatives, most notably the so-called patent package that was put forward in late April and consists of several different proposals. The Commission proposes a revision of the legislation of supplementary protection certificates, as well as new regulations on compulsory licensing and standard essential patents. During the remainder of the Swedish presidency, we will focus on advancing the negotiations on supplementary protection certificates that are, of course, closely linked to the unitary patent system. The Commission recently also adopted a recommendation of specific interest for the context of this summit, namely the recommendation on how to combat commercial-scale online piracy of sports and other live events, such as concerts and theater performances. By stepping up the fight against online piracy, the recommendation will contribute to strengthening the competitiveness of the EU sport and creative industries. The Commission will, together with the EUIPO Observatory, monitor and evaluate the effects of the recommendation by 2025 and then decide whether additional measures are needed at EU level. As a final point, I would like to say a few words on a truly remarkable European success story of which Sweden has always been a fierce supporter. As you're of course aware of, on June 1st this year, the unitary patent system was finally launched, marking the end of a very long saga, covering almost 7 decades of negotiations. I am convinced that this new system, in simplifying procedures and thereby saving both time and money for innovative businesses, will provide a major boost for innovation and competitiveness in Europe. The unitary patent system is indeed a game changer for the EU's innovative industry. The possibility of litigation and access to competent and effective courts is of course of fundamental importance when it comes to tackling intellectual property rights infringements. It is, however, just one small piece in the bigger puzzle that must be solved if we are to successfully combat piracy, counterfeiting, and similar unlawful behavior. As legislators, our responsibility is, of course, to ensure that the intellectual property rights framework provides a high level of protection for right holders and is up to date in order to combat new challenges, often brought about by technological development. Public authorities, such as police and prosecutors, must have the skills and the tools they need to effectively enforce the protection, and there must be adequate penalties in place for those who infringe the intellectual property rights of others. As an example, in Sweden, we have fairly recently introduced tougher penalties for the most serious intellectual property infringements, increasing the maximum penalty for serious infringement from 2 years of imprisonment to 6 years. A robust legal framework and effective national law enforcement is of course essential in the fight against piracy and counterfeiting. But as these international IP enforcement summits show, this is not enough. This is truly an international problem to which an international response is needed. We need to do more, and we need to do it together, both within the European Union and globally. In that context, it is of course very pleasing that the fight against intellectual property rights infringements is among the priorities of EMPACT for the coming years. As is also highlighted by this summit, both the public and private sectors and all actors in the value chain must contribute if we are truly going to be successful. In this, I do believe that the discussions you have had over the last days will be a great contribution to the work that lies ahead of us. Thank you.